Iku Iluna, please rise. Ia ka aha ho kolo kolo ki ike hano hano ua a koa koa ho maila. This Honorable Supreme Court is now reconvened. Inoho ilalo, please be seated.
All right, please call the case.
SCWC-18-0000099, Wilmington Savings Fund Society, FSB, doing business as Christiana Trust, as trustee for BCAT 2015-14BTT, respondent, plaintiff, and appellee, versus Isabella Paco Domingo and Michelle Eleanor Domingo, petitioners, defendants, appellants, and Bank of America, N.A., and Halavili Place Community Association, respondents, defendants, appellees. Frederick R. Meyer arguing for petitioners. David Rosen arguing for respondents. Justin Moyer also appearing. Argument on the merits.
All right, good afternoon, aloha everyone. Our proceeding today is being broadcast live on our YouTube channel, as well as on Fellow. And I welcome our two justices, Judge Catherine Remigio and Judge Kevin Souza. Mahalo to them. Counsel, are you both ready to proceed? All right, we've allocated 30 minutes to each side. Mr. Arnsmeyer, you reserved 18 minutes for your opening argument, 12 minutes for rebuttal, so we'll give you a warning 18 minutes in. Mr. Rosen will give you a warning with 5 minutes to go. Mr. Arnsmeyer, please proceed.
I'd like to start by thanking the court for accepting review. This is the second time in this case, and quite honestly, it's been a struggle on behalf of my clients to seek any meaningful appellate review on the merits. This is a problem that plagues foreclosure cases, generally speaking, across the board. This case is another example of the requirement of a supersedious bond being used by our courts as a means of discouraging, if not outright preventing, meaningful appellate review. In this foreclosure case, the plaintiff, clearly in violation of the Uniform Commercial Code, proceeded with a foreclosure even though the note had been lost. It had no authority to proceed under the statute.
Are we going to address the merits?
I'm only giving background at this point. The merits, to my understanding, are not before the court today. Again, that is our ultimate goal in this case, is to have an appellate court reach the merits of that argument. Again, we've been unable to get that far. After a decree of foreclosure was entered in this case, we did seek a stay pending appeal because that's what the rules say. That's what you're supposed to do. And the circuit court judge, not only did he not set the amount of a supersedious bond, he just flat denied the motion. No amount was set, so, well, we went up to the Intermediate Court of Appeals under Rule 8 and sought a stay in front of the Intermediate Court of Appeals. They did grant the motion, but they set the amount of bond at $300,000. Keep in mind, this is a residential foreclosure case. These are people who are accused of falling behind on monthly mortgage payments of several $1,000s a month. It is impossible for a homeowner in a foreclosure case to ever post a bond in that amount of money. In any event, we don't believe that a bond was necessary in this case, and this is where the ICA got it wrong. The ICA many years ago adopted a rule that we've referred to in this case as the Citibank rule. It's a question of mootness. And under that mootness doctrine announced in Citibank and later adopted by this court in the Onaga case, a case is generally speaking, a foreclosure case is generally speaking moot if a defending appealing party does not post a supersedious bond. Now, there are two very clear exceptions to that. If appellate reversal is based on jurisdictional grounds, or where the purchaser of the party at the foreclosure, at the judicial foreclosure sale, is the plaintiff or is a party to the case. And the reason for that, the reason set forth in the case law, that's a party to the case, they don't free themselves from the dispute simply by purchasing the property.
But counsel, you indicated, and the record does reflect, that when the motion that was denied in the Third Circuit, your initial motion, you actually filed a motion to set a bond?
Yes, Your Honor.
But your argument here is that a bond is not required?
That's right. That's right.
Oh, but you requested that the Third Circuit set one.
We did, and had one been set, and had it been affordable, and had my clients set a supersedious bond, we wouldn't be here today on this issue. We might be here on other issues, but we did make that attempt, and quite honestly, over the years, I've, as a foreclosure practitioner, less and less been willing to even spend my clients' monies to seek that kind of a bond. I still do if clients want to, but generally speaking, maybe I've had two cases over the years where a bond has actually been set that's affordable, that's reasonable, that's meaningful. But generally speaking, our courts set supersedious bonds that are outlandish. And in this case, this property had equity. Plaintiff's interests were protected. Over the course of the appeal, interest was going to continue to accrue under the loan. And that interest would add up. The value of the property would have been enough. In any event, we offered to post bond on top of that. That was denied by the circuit court. In any event, I'm here today to complain about the Intermediate Court of Appeals interpretation of the Citibank rule and its determination that a non-judicial foreclosure purchaser is somehow a bona fide purchaser for value, even though they have actual knowledge of a pending wrongful foreclosure lawsuit. Even though, in accordance with the statute that controls in land court, there was a valid lis pendens recorded on the certificate of title for the property, that this third-party purchaser, this non-party who purchased 3 years, 4 years after the foreclosure, had full knowledge of. Now, I believe the ICA relied heavily on a case from Maryland, Creative Development Corporation versus Bond. And I think that's where the mistake stems from. Unlike here, that case involved a judicial foreclosure sale to a third-party purchaser, not to a bank. In any event, that case involved Maryland law. It didn't involve any analysis of this Citibank rule, but even if it did, even if that case had been brought in Hawaii, the result in that case would have been the same because we weren't dealing with a plaintiff purchaser as we were in this case. And the second...
Well, Maryland clearly recognizes the two exceptions recognized in Citibank as well as in Onaga.
They do in other cases. And my point is that they did not appear to evaluate that in this case. And I submit to you that they didn't have to. It didn't apply. And that's because, again, the purchaser was a third-party purchaser. under the Citibank rule, when you have a third-party purchaser, everyone agrees a supersedeas bond is mandatory. If you don't post a bond, generally speaking, your appeal becomes moot. And that's what happened in that case. That case also, similar to this case, involved a separate lawsuit, but in that case, the mortgage borrower, the plaintiff in the separate lawsuit, filed a case seeking to enjoin the third-party judicial sale purchaser from selling the property. We didn't do that here. We filed a lis pendens. Lis pendens is basically notice to the world saying, if you purchase this property, it's subject to a dispute. That does not mean the plaintiff could not sell it.
I have a question along those lines. In your cert app, in this cert app, you quote our decision at Bank of America versus Reyes Toledo, in which there was a passage which said that we're not saying that the counterclaim has to be filed. But, you know, the facts of that case were quite different. That was a situation in which the ICA had actually held that you couldn't file a wrongful foreclosure counterclaim before the foreclosure had taken place. So you couldn't, if the lender sought to foreclose, you couldn't file a wrongful foreclosure counterclaim. And we said that's not true, that's not right. You can file a wrongful foreclosure counterclaim without the foreclosure actually having been completed. And then we said, but we're not saying that it has to be filed as a counterclaim. But so the facts of that case were really different. And I'm wondering, your complaint, in your separate complaint, were you not alleging the same things that were the defenses in this underlying foreclosure case? Or were you asserting new claims?
We were asserting things that were raised, in fact, as defenses.
Right, so why wasn't that a compulsory counterclaim?
Well,
it arises out of the transaction, the act, so it seems like that's a compulsory counterclaim. Why would we have separate lawsuits when the court had already ruled? Isn't that a collateral attack on the judgment?
Yes, it is a collateral attack on a judgment. But the difference here, and I think this is important, is that the facts giving rise to this argument that Wilmington had no authority to enforce the note, those facts didn't exist at the time that this complaint was filed and originally.
But they existed at the time they moved for summary judgment, the second time interlocutory decree of foreclosure, right?
It did. But
and you raised that as a defense in that case. And that is the merits of your appeal in this case, the foreclosure case. You're alleging that they didn't have authority to foreclose based on the lost note doctrine.
They are, but again, that lack of authority didn't arise until an order was entered by the circuit court granting leave to substitute Wilmington in place of Bank of America, the party that filed this case, saying we had possession of the note when it was lost. Problem here is during the case then, after the complaint was filed,
they substituted?
They substituted.
And then they moved for summary judgment.
That's right.
And they moved for summary judgment on the basis that they had this, well, the renewed motion, that they had this affidavit of lost note, and it had been assigned to them, right?
That's right. So I would submit that we could have filed a counterclaim. I'm not sure.
Why isn't that a compulsory counterclaim? It arises out of the exact claim that they were making against you.
But it doesn't. If we look at the complaint, it was Bank of America saying, we held the note when it was lost. To answer that complaint, we didn't have that defense. That defense didn't arise. Those were new facts that happened after the case was filed. So two things could have been done.
Let me ask you this. Say you're correct and maybe, the new facts arose after. Do you disagree with the proposition that, res judicata principles, Hawaii Rules of Civil Procedure Rule 13, that those ideas justify a compulsory counterclaim way for you to proceed?
First of all, on the issue of claim preclusion, res judicata, under the law, as I understand it in Hawaii, that does not attach until a judgment becomes final. As long as a judgment has been appealed and remains pending on appeal, it's not final. As for, again, a compulsory counterclaim, I would submit it would have to relate back to the allegations in the original complaint.
And you had already filed an answer? You had filed an answer?
Yes, and to the date that the...
You had filed an answer to the original complaint?
We had. I don't recall offhand the timing of it or even what was raised in it.
And they didn't move to amend the complaint to make them like the new plaintiff or anything like that?
Not that I recall, no.
But if the facts are known and there's no additional parties required, what's your position on whether it should be raised as a compulsory counterclaim?
Again, I don't believe it should be. I think two things could have happened. It would not have been a compulsory counterclaim because it would not have related back to the original complaint. It was based on new facts. If anything, we could have pled a supplemental pleading, facts that have occurred since the original transaction or occurrence, or we could file a separate lawsuit. And if we take a further step back to what Justice McKenna initially raised was, well, this court heard the Reyes-Toledo case several years ago, and the proposition in that case is, well, should we permit you to file a counterclaim in a foreclosure case? It seems to me, reading that case, the presumption was, at least at that time, no, you need to wait for that foreclosure to happen, and then you can challenge it. That was the whole point of the second Reyes-Toledo case, was to carve out an exception so that to say, hey, in light of preserving judicial resources, you have this option. You can do this, but the court was very clear in its language and said, you don't have to. It does not have to be raised as a compulsory counterclaim.
Can I bring you back to the Citibank argument and Onaga and the exception when the purchaser is the mortgagee? Why should that same rule or should it not apply, or why shouldn't we apply that same rule in a circumstance here where there's been, I guess, a sale to a good faith or a bona fide purchaser? At least that's what the Third Circuit concluded was the sale. So what's your take on that? Because I think the ICA determined that because there was admittedly the exception would apply, but there had been a resale of the property to a bona fide or good faith purchaser. So why don't we still have the same notion that you had to have posted a bond? What's your take on that?
So I think that was touched on in our reply, and it really goes back to what was the purpose, what was the policy of this rule, this Citibank rule, this mootness doctrine. And the purpose very clearly under the case law was to promote the finality of judicial sales. It has everything to do with promoting judicial sales. We want to encourage people to come out, encourage competitive bidding to achieve the best price of the possible when property is properly and lawfully foreclosed. That's a good policy. But in this kind of a case, it has that rule, that policy would not apply. Here we have a sale that's admittedly years after the fact. Plaintiff had other options that they didn't pursue. And they chose to sell the property for admittedly far less than it was worth. Has nothing to do with promotion of judicial sales. And in fact, I would submit that the judicial sale in this case, despite all of those policies, we still had the plaintiff bidding and basically getting the property for less than it was really worth. So, to extend that rule, to apply it in these circumstances, I don't think it serves any judicial policy. Now, it might serve the interests of investors. But I think this court needs to weigh everybody's interests. And one of the most important interests, and one of the first things I raised today, was access to justice, access to meaningful appellate review.
Did you appeal the $300,000, figure that was set by the ICA? And if not, is that something we should consider?
Well, I don't know that that's something that I could have appealed. Perhaps I could have filed a cert petition.
Yeah, that's what I meant.
On that
I'm sorry.
issue. I did not. Is it something the court can consider? I think as background, yes. As facts of the appellate procedure, yes. But I'm not here today to have that overturned. It wouldn't do me any good to do so. But I do think it's an issue that can be addressed. I don't think that the court necessarily needs to find error or order anything reversed, but it's a fact that should be considered.
I mean, go ahead. No.
You are arguing that it was improper to set that, right, pursuant to the Citibank rule?
No,
or not?
No. I'm arguing that it was improper for the circuit court not to set any bond, and I'm arguing that the ICA's setting of the amount of $300,000 was impractical. It was excessive. But again, that's
so you're not arguing that pursuant to Citibank, it shouldn't have been, no supersedious bond should have been required because the Wilmington purchased at the foreclosure sale. Oh, because you didn't know who was going to buy it at the time you filed the motion. It was before the sale that you filed the motion.
If I recall, that's correct.
Right,
correct. I don't
right.
remember offhand, but just practically speaking, that would make sense. There would be a decree of foreclosure, a commissioner would be appointed, and then there'd be a 6-month to 1-year process as far as advertising, selling, and.
Wait, in your appeal from the foreclosure sale, confirmation of sale, was there briefing from that?
I don't believe there was.
I don't think there was
briefing.
any additional briefing, right? So you didn't actually challenge. What did you challenge in terms of the appeal of the confirmation?
That was really an appeal as a matter of caution. To the
So
extent.
you did not appeal, as the Chief Justice has asked, the amount of the bond that was set. Oh, because the ICA had set it, so I guess you couldn't appeal what they set.
Again, that's not an issue that we've raised before this court. It's certainly an issue that's come up in this procedure. But the amount of the bond is not why we're here today. I'm just
Why are we here today?
We need clarification on the Citibank rule. The Citibank rule has existed now for several decades. We've relied on it. It's good policy. The exceptions to it make sense. And the ICA said, okay, well, we're going to curtail the protections for mortgage borrowers to appeal under that rule because, okay, we've always said that you can pursue an appeal as long as the plaintiff in your case is the purchaser at the judicial sale. If this decision is left to stand, and I'll emphasize it's a published decision, that's one more right that homeowners, that defendants in these cases, they don't have. That's that much less access to justice, to meaningful.
So what are you asking this court to rule on that issue? I'm a little confused. What are you asking?
I'm asking this court to set aside the ICA's dismissal order.
On what basis?
And follow the exception to the Citibank rule that says no supersedious bond is required following a judicial sale to the plaintiff. The question then, in the case where a plaintiff then sells to a third party, is that third party a bona fide purchaser for value? That's a different inquiry. That's not part of the Citibank rule. Mm-hmm. And that was our position in this case. Okay, plaintiff can go ahead and sell, but then the question is the purchaser a bona fide purchaser? If they are, we can't recover title. But if they're not, and we submit that they're not for various reasons, title is still fair game.
Even if the purchasers have not been brought in as parties.
That's
How are
right.
they not indispensable parties at this point?
Practically speaking, there's no sense in joining them to the lawsuit at this point.
Why?
Well,
You're
it's,
trying to set aside title that they have acquired.
at this point, our appeal's been dismissed. If the appeal's reinstated, if we are actually going to get a decision on the merits, then it makes sense to spend that money, bother these people with serving them with a complaint, requiring them to file answers, get lawyers, become parties to this. But until we have a decision on the merits, on this legal issue, it doesn't seem like a good use of judicial resources. Now, I am sensitive that there are statutes of limitation that may be in play, and you know, we're keeping an eye on that. But those additional parties can be brought in, and they will at the appropriate time. I see that my orange light is on.
Anything further for the court at this time, or do you want to reserve your time for rebuttal?
I'll reserve rebuttal.
Very well, Mr. Arnsmeyer. Thank you. Mr. Rosen.
Good afternoon. May it please the court. David Rosen and Justin Moyer for Plaintiff Appellee Wilmington Savings Fund Society as trustee. Typically, I try and do my opening, and very quickly questions start coming in, and I very rarely get to complete it. But here I want to address, before even getting to what I had prepared, addressing the dialogue that went on between the court and Mr. Arnsmeyer, because I think it's
Pull the
very
mic down just a little bit. Thank you. Just pull the mic down a bit.
Okay.
Yeah, there we go. Thank you.
I think it's very telling, and I think I appreciate the justices' questions, which I think really hone in on the critical issues here. Mr. Arnsmeyer said if the lender is the buyer at the foreclosure, then a third-party sale can never invalidate an appeal. In other words, a bond is never required, and the lender can't sell the property.
I'm not sure that's what he said, but I mean, after, why wouldn't, well, once the lender has sold it, why would you really have an interest in then moving for the setting of a supersedious bond yourself at that point? Because you've already sold it. You're kind of out of it already, huh? Oh, well, you still have the appeal, so you want to make sure that your appeal is upheld.
Let me rephrase that. Maybe it'll be clearer. So what Mr. Arnsmeyer is saying, to my understanding, is if a lender is the buyer at the foreclosure sale, the borrower can appeal and doesn't need to post a bond, and the lender cannot sell the property until the appeal is completed. I think that's what he's arguing. That's my understanding. I mean, it's kind of...
What's your response to his argument that that's going beyond, or whatever policy arguments might be raised about that it's not what the Citibank rule was about? Because he said the Citibank rule was all about ensuring the best possible price at judicial foreclosure sales. Now you're talking about third-party sales that are taking place in private. So you've gone beyond the purpose of the Citibank rule. What was your response to, or what is your response to that?
Well, what Citibank says, and Onaga, is that when there is a sale to a third party, and it doesn't have to be at the foreclosure, when there's a sale to a third party, it moots the appeal. As a practical matter, when this court's aware, there are two stages to a judicial foreclosure. There's summary judgment and an interlocutory decree gets entered. That really completes the foreclosure. It says the property's foreclosed. There's a second phase that the property then goes to auction and the sale is confirmed. And at that phase, the issue was the sale price fair and reasonable.
Do you know if Maryland splits it into two?
Maryland is actually doesn't do foreclosures the same way as Hawaii does. It's a deed of trust jurisdiction.
Right.
So it's not apples to apples.
Do they split it the way we do?
So in Maryland, because it's a deed of trust jurisdiction, the lender holds title to the property throughout the duration of the loan. So it's a very different
Right.
situation.
Right.
The creative design case, though, is still applicable. I mean, it's not precedent, obviously. It's a Maryland case. It's old, but it's persuasive. It discusses the consequences that would result if a borrower went through the foreclosure and then filed a new action to create a new cloud on title. That's what happened here. That's exactly what happened here. This was a compulsory claim. Mr. Ehrensmeyer got his facts wrong. So the original complaint was filed by Bank of America. My client substituted into the case and filed an amended complaint.
You did file an amended complaint.
Yes, we did. We filed an amended complaint where we raised the issue of the lost note. The motion for summary judgment, 2 motions for summary judgment were filed. Both of them raised the lost note issue. The judge who decided the first one said, if you're going to say that the note was lost, you have to show me that you made an attempt to find it or what was done to try and locate it. That was the only basis on which the original MSJ was denied. So the amended MSJ addresses that issue. There's a very detailed declaration from Bank of America and its servicer explaining what was done. And in addition, there is an indemnification that came with that, where Bank of America said, hey, we lost the note. We sold the interest to Wilmington. But if anyone ever comes and tries to assert and enforce the note, we'll indemnify the Domingos. So they don't have any liability. It's actually required by the UCC, and Bank of America did it. They didn't have any exposure. But during the MSJ, the amended MSJ process, between when it was filed and when it was decided, the amended complaint was filed, and the Domingos filed an answer. They already had notice of the lost note. They had already argued why they believed Wilmington didn't have standing, and yet they didn't assert a counterclaim. This is very unique in that the amended MSJ gets filed, and after it's filed, the amended complaint gets filed. So they filed their answer between when the amended MSJ was filed and when it was decided. They could have, and they clearly should have, asserted their argument as a compulsory counterclaim. They chose not to. Why did they choose not to? Because as soon as the MSJ got decided in favor of Wilmington, they filed an appeal. The foreclosure proceeded, it went to confirmation. But what is the effect? This is a critical issue. And I really want this court to understand as a practical matter. Yeah, I've been doing this for 30 years. I've dealt with thousands of judicial foreclosures. I've argued and briefed nearly 100 appeals in front of this court and the ICA. And it's, this court, you're each expected to be experts in every area of the law. It's not possible. I know, Justice McKenna, you did have experience with foreclosures. I don't know that anyone else on this court has.
It really doesn't matter, Mr.
Yes,
Rosen.
yes,
Can you focus on, not on our expertise, but rather on your arguments?
Sure. The practical effect of when an appeal is filed in response to the interlocutory decree is that you can't get title insurance. A buyer who appears at the auction or the confirmation hearing is going to need to be a cash buyer as long as an appeal is pending. So that's why at the confirmation hearing, these properties tend to go back to the lender, based on the lender's credit bid. And in this case, there was not equity at the confirmation hearing. This property, the sale, the confirmed sale, resulted in a $20,000 deficiency. So the lender credit bid, mostly of what it was owed, but there was no equity in the property. So Mr. Ehrensmeyer's assertion that there was equity and that should have satisfied and covered any loss that occurred during the duration of the appeal simply is not true.
So as a practical matter, the rule that, the Citibank rule that says that if the purchaser, the mortgagee purchases at the foreclosure sale, you don't need a supersedious bond. It doesn't really make much sense in Hawaii because
It's
if you
always
want to
gonna be-
appeal the foreclosure, you don't know who's buying.
Well, it's always going to be the lender that buys it if there's an appeal pending. It's always going to be the lender. And
Never
that's,
anyone else?
no, because again, they're going to have to be a cash buyer. In this situation, the lender was owed approximately what the property's fair market value was. So nobody's going to come in and bid more than that or even close to that when they can't get title insurance, they can't get a loan, they can't resell the property. And according to Mr. Ahrensmeyer, you have to hold it until the appeal's decided. So now anyone who buys it is going to have this cloud on title that could go on for 4+ years, which is how long appeals are taking. And look at what happened here. This is why title insurers won't offer title insurance. Because here, not just my client's buyer, but that party's buyer now has clouded title on their these certificates of title. Was noted the NOPA that Mr. Ahrensmeyer filed in this.
So are you suggesting we should overrule that Citibank exception? I mean, it seems where your argument is going, that it's a bad policy.
I don't see it as being, I think the exception is fine, except that it needs to be expanded upon. It needs to be rational. And the rational expansion of that simply clarifies that when the lender sells to a bona fide third party for value, the same thing happens. The borrower's claim against the property disappears. Does the borrower retain a right to sue for damages? Of course. Of course. This court has decided that. You retain, when the property is gone, you still have a claim for damages. So even if they felt that they still have a wrongful foreclosure claim, there's a remedy for them. They're not without a remedy. But the remedy is not against the property, and it can't be. We need common sense here. This has now been over 5-6 years since the foreclosure was confirmed. We need to have finality so that we can get the title companies to understand that once the foreclosure occurs, if there is no bond posted, and it needs to be clear, if there's no bond posted, any claim that the borrower had against the property is gone. That's what the confirmation order says.
If it's a good faith sale, or I'm trying to understand your rule.
I think it's fair to say if it's a good faith sale. Yeah. I mean, if the lender sells to an affiliate, that's problematic, obviously.
Okay.
That's circumventing the intent. But
But
here,
you're saying, before that, I heard you saying you thought that should be the rule at the time of the foreclosure judgment, the interlocutory decree, not after the sale.
so we're talking about now at the point at which title insurance would become an issue, which is at confirmation.
At confirmation.
And it's understood, again, at confirmation, the judgment gets entered. There's 30 days to notice an appeal. During that time, the borrower can also seek to post a bond or to seek a stay. So that 30-day period could get extended to maybe 60 or 90 days to a reasonable period to post a bond had expired. But even at 90 days, there needs to be a clear, bright line date. After that date, if you haven't posted a bond, if no stay has been issued, then any subsequent sale is free and clear of any claims that the borrowers might
That's
have
the
had.
rule you want us to adopt, or
Yes. Yes.
So we would be overruling Onaga.
I don't think it's overruling because they didn't deal with this specific situation. I think it's a clarification and an expansion.
It did say that if the mortgagee buys, you don't need a bond.
But it doesn't talk about what happens if the mortgagee then sells to another third party.
What I'm being confused by is that you're back to the confirmation sale, which presumably there's no third party buyer at that point. So again, I'm trying to understand the mechanics of what you're arguing for.
Thank you. So the clarity that's provided, again, is not when the lender buys it to foreclosure, it's not going to have clear title.
Right.
But we then need like a 90-day period to pass. And at the end of that 90-day period, the lender should be able to convey to a BFP, a third-party BFT, clear title.
Isn't that the kind of thing that should be subject to a rule? I mean, if you just say we should adopt by decision a rule that says there has to be a motion for a supersedeas bond within 90 days of the purchase of the property?
So
we're going to create that out of whole cloth? I'm just trying to understand what you're arguing
that's
for.
a very fair question. And we're dealing with equity here. Equity is what allows this gray area in the first place. We have to have a practical mechanism for completing foreclosures within a reasonable amount of time.
But if we go by the facts of this case,
Yeah.
as Mr. Arnsmeyer has said, when he was going to, he filed the appeal of the foreclosure judgment, and he moved for a bond
No,
at the Third Circuit.
no. So when he filed the initial appeal from the interlocutory decree, no bond was sought at that point.
Oh,
The
when
bond-
did he seek it?
The bond was only sought after confirmation.
I'm trying to understand. You're looking for a holding that would
No,
say
no. He filed a motion to stay on April 16th of 2018
The,
before the May sale.
I believe that the $300,000, and I could be wrong, I apologize.
It was issued on May 11th of 2018.
Okay, then that would have been before
And
the
the sale
confirmation
was
hearing.
May 29th. So
Okay, then that would be
he
before.
moved
Yeah,
in the Third Circuit in March.
that's very unusual. And I will.
So this is unusual.
Yeah, that's unusual that a party would seek a stay before the sale.
I see.
But that's what happened here. So
Because he didn't know who was going to buy. And that's why he requested a bond. Because if it wasn't your client that bought per Citibank, you would need a bond.
yeah, but what it really does is it chills bidding. It scares off anyone who wants to come in and bid because they don't know if a bond's going to be posted. If they bid at the auction, they have to make a 10% deposit and their money can get held up for months, years. So
you're talking about something much more sweeping here, right? Which is a requirement of a bond being in place before the confirmation sale. Again, I'm just trying to understand what
No.
you're advocating for. We have a narrow set of facts here where I guess the Domingos sought a bond, didn't get it, didn't file, couldn't comply with the bond that was ordered. It's undisputed that happened, and then there was a third-party sale. It's a relatively narrow set of facts. You would argue on that set of facts that there's clear title to the third-party purchaser, correct? I mean, that's the narrow. That's if we're going to limit it to the facts of this case, that would be the holding that you're advocating for, I would assume.
yes,
So you want us to go farther and say what?
it's necessary because we need to have clarity. Title companies need to be able to understand, and buyers need to be able to understand what they're getting. And
Isn't this an issue for the legislature?
it's not, though, and that's not going to happen. Our foreclosure statute is a very vague statute.
It's an old one because some states have much more
Yeah.
specific statutes, right?
And this court has said to the legislature, we need a more developed it hasn't happened, and it's unlikely to happen. But we have thousands, if not tens of thousands, of pending foreclosure cases. And right now what's happening is that nobody knows what's going to happen. And so buyers just don't want to buy. These properties sit and they dilapidate, and associations can't collect their association dues, which affects other members. It's an unworkable situation. So under Citibank, we have some guidance. I mean, the court could simply say, it could create a bright line rule that's less generous than what I'm suggesting. It could simply say, if you want to stay confirmation, you need to file the request for stay before the confirmation hearing, before the confirmation order gets entered. And if you haven't posted the bond before the confirmation order and judgment get entered, that's it. Any appeal that you file doesn't create a lien, doesn't create a continuing right. That would be a clear, bright line rule. So,
Yeah, I understand the whole reason for the Citibank rule exception and the requirement to try to encourage non-party individuals to bid on foreclosure sales. But we're talking about the exception being that the mortgagee is the purchaser. And the whole purpose of that exception was to say that if you folks are the purchasers, then you're not freeing yourself from the underlying dispute, you're a party. And so there's no question about title. But what happens is you immediately turned around and freed yourself from the underlying dispute by offloading the property to a third party. And your argument is that, well, let's analyze it as not a good faith purchaser, but I believe a bona fide purchaser. And under that analysis, we're talking about how much the property was worth after you add all of the penalties and interest. Or are you talking about, because my understanding is the sale was was it $400,000?
So my client credit bid just under $900,000 at the confirmation hearing. It didn't immediately try and sell the property. What it tried to do was, in all honesty, negotiate with the Domingos. Those negotiations failed, and my client had regulatory pressure that it couldn't continue to hold this asset, which is called an REO, real estate owned. It couldn't continue to hold this asset on its books indefinitely. We were at 3.5, 4 years on the pending appeal at that point. And so my client put it out for sale to third parties, and it received multiple offers. The highest one was accepted and resulted in my client taking a loss of about $400,000 at that point. $400,000, but it didn't have any alternative.
But what was the market value of the property versus the sale price?
So the market value of the property when my client sold it, the problem is the market value is affected by the NOPA and the pending appeal. And
this
so
might not seem fair to you, but what would the market value have been without the NOPA?
it would have probably been around $800,000 if there were no liens or no litigation. $800,000 to $900,000.
And under those circumstances, are you seeing that the subsequent purchaser, I mean, I know we ended up with someone after that, is a bona fide purchaser?
He was, and that was the determination made by the circuit court on remand.
Well, in terms of that, I'm so sorry.
Yeah.
Please go ahead.
Yeah, but can I just say one more thing?
Sure.
But beyond that, the buyer then resold the property
Right.
for very little more than he had bought it for. So that kind of determines twice what the fair market value with the pending litigation was.
I guess one of my concerns is that we're being asked to make a decision based on the manner in which the real estate market, the title insurance, all of these are working. And I think the question of whether this is something that we should be doing is a legitimate question.
And that's fair. And I think that the simplest way to address this is to deal with it narrowly and to say, in this instance, the sale to the third party mooted the pending appeal. A sale to a bona fide purchaser moots a pending appeal where there is no stay, there's no bond posted.
How does a purchaser who takes with knowledge of the list pendants and listed as an encumbrance on the TCT how can that person qualify as a bona fide purchaser under our current definition of BFP? It's supposed to be a person that
Because
takes without knowledge
They're,
or
they're
notice.
they are, as the ICA stated in their SDO, they're relying upon the completed foreclosure, the completed judicial foreclosure.
I understand, but the way BFP has been defined by our case law up until now is it has to be someone that purchases without knowledge of the alleged title, problems in title.
The alternative is that lenders credit bid and they can never sell the property. They have to wait 4+ years. This is not tenable. We are in a and this is the situation we're in. We need a clear indication from this court to persuade buyers and title insurers that there's a bright line.
Is this because there's so many more judicial foreclosures now after the non-judicial?
No.
This has been going on forever, right?
No, it hasn't actually.
What triggered the current situation?
The confusing and unpredictable state of foreclosure law in Hawaii. Title insurers said, we're done. It didn't always exist like this, and probably 10 years ago, after the confirmation hearing, 9 out of 10 title insurance would be no problem. We had plenty of buyers. We had plenty of people showing up to bid, and fair market value at the confirmation hearing was being achieved. Sometimes it would go over fair market value, depending upon the market. Right now, nobody will touch these properties. The appeals are taking too long, and it's unpredictable. That's the situation we're in. So whatever this court's decision is, I would pray that it's clear, that it provides clear guidance and a bright line, because what Mr. Ahrensmeyer is arguing, that if a lender bids at the confirmation hearing, and again, we had no choice. No other bidders showed up. There was no one else there. So my client did credit bid its claim, but it had no choice. If it didn't, what happens to the foreclosure? It just sits. Is it dismissed? I don't even know. But my client credit bid, it took the property. It shouldn't have to hold that property, pay the real property taxes, maintain the property, take all the risk indefinitely until appeals are exhausted. In fact, most of these lenders are not allowed to do that. They have strict regulatory requirements that have deadlines. And, 4 years, it used to be 18 months, which was still borderline, but we're over 4 years now to have the ICA decide these cases. I just had 2 come out, and they were over 4 years old. And, that they have to get rid of these assets. The properties deteriorate very quickly when they're not occupied. You have squatters moving in.
What about the Liz pendants? What's your take on, is there clarity that needs to be brought to the effect of a Liz pendants being filed in this situation? Or is that resolved if we address if we hold the way you just argued that we should hold?
That Liz pendants really raises issues under utsunomiya.
Under?
Utsunomiya. Okay. Yeah, I think there's a good argument that's sanctionable, and a fine should be imposed for filing that after knowing that the foreclosure was completed, no stay was obtained. If Mr. Ahrensmeyer is correct and Citibank doesn't apply, they didn't need the NOPA.
It seems to me that based on Lathrop versus Sakatani, perhaps a motion to expunge the Liz pendants might have been granted, but the issue is no one who's incentivized to file that motion.
Right. My client didn't own the property.
Right. And so it would have to be one of the subsequent buyers.
And they weren't named. They're not a party.
They're not parties. Right.
Yeah. That wrongful foreclosure action's been pending for 5.5 years. And my client's buyer and their buyer still haven't been identified as parties. You can't just file a NOPA and then sit on it indefinitely. Mr. Ahrensmeyer and his client should have proceeded on that case. The case in it itself, I think we've already gone over this. This court's not going to reach the merits on that, but it involves the same claims that were raised in the foreclosure.
What does it take, though, to expunge a lis pendens that's in land court? You actually have to go to land court and file a motion, right?
Yes. And the land court, the difficulty in getting that type of issue resolved in the land court would be problematic. And it would be time consuming and expensive. And as your honors recognize, who would have the interest in going through that exercise?
I guess if the buyer wanted to sell for fair market value, they might go through the
And I think what ended up happening is the current, and again, there may have been subsequent sales, but my client's buyer's buyer are residing in the property. They are residents and they are living in the property. And so they don't have any immediate need to go and seek to resolve that.
Are you suggesting that they were unable to get title insurance?
I don't know what the situation is, to be honest. I don't know if again, we weren't involved in that transaction.
Right.
I didn't even, I have to apologize, I didn't even know about it when we were doing the briefing on remand. We found out during that process that the buyer had sold it again. And we did alert the court to that. So I think my time is up.
Anything further you wanted to bring to our attention, Mr. Rosen?
Thank you very much.
All right, thank you for your argument. Mr. Arnsmeyer, your rebuttal.
Mr. Rosen argues that the bank had no alternative. Here they were stuck holding a property that was not marketable.
Can you lift the microphone?
They did have alternatives. And as Your Honor, Justice McKenna touched on, there was this separate lawsuit filed while they were holding title. They could have moved to dismiss and expunge the lis pendens. That may or may not have been granted. I don't know. That issue then could have been taken up on appeal, but they would have been free of that lis pendens. Presumably then, okay, now you've got a property that's not subject to a lis pendens, it's worth more. You can't criticize appellants for depressing the value of foreclosed property. What Mr. Rosen is advocating for today is basically to eliminate the ability for any foreclosure borrower, any defendant in foreclosure, have any meaningful recourse for appellate review unless they're lucky enough, and very few ever are, to achieve the setting of a supersedious bond that's reasonable and affordable and that they can handle. Otherwise, what we've seen here, well, the circuit court said no, the ICA said sure, put up $300,000. No homeowner in foreclosure can do that. If they could, they wouldn't be in foreclosure to start with. So this is really a question of access, and this court is in a position to balance interest. It's not this court's role to maximize returns for banks.
Hasn't this court already weighed in on that issue, Mr. Arnsmeyer? Hasn't the Supreme Court in the Latham versus Sakatani case that Justice McKenna recognized or referred to said that a lis pendens does not serve the same function as a stay?
That's absolutely correct.
So absent absent a supersedious bond, how does your client achieve a stay in this case?
Well, we didn't file the lis pendens to achieve a stay. And again, Mr. Rosen mischaracterized our position in this case. We didn't file a lis pendens to say that the plaintiff can't sell the property. Of course they can.
But subject to
the
encumbrance created by your lis pendens.
That's correct. And so then if Mr. Rosen's client believed that lis pendens was somehow not appropriate for whatever reason, be it the compulsory counterclaim doctrine or something else, they had recourse. File a motion in the circuit court case to dismiss and expunge the lis pendens. Now there's this issue. Okay, well, what about land court? Land court has concurrent jurisdiction with the circuit court on these issues. Once the circuit court issues a determination in a case and orders a lis pendens expunged, that can be registered with the land court. It's not a big, complicated process. You know, there is this question: was this a compulsory counterclaim or not? I would submit that question's not before this court. It may have been had the plaintiff availed themselves of their alternatives. They're here today saying we had no other alternative. Well, yes, you did. And perhaps had you taken advantage of that alternative, again, I don't know. Had they been successful, they may very well have been able to sell the property to a bona fide third-party purchaser for much more than what they ultimately recovered. But they sat on their hands for 4 years, did nothing. Did nothing. That litigation is, you know, it's still there. It's still pending. It's still subject to lis pendens. Anybody that buys the property going forward, as long as that lis pendens remains, takes with notice of this other dispute, this other lawsuit, which isn't before this court.
So can I understand your client, you're saying your client did not attempt to achieve a stay of the foreclosure sale, but part of the relief that your client is praying for in the separate lawsuit is a quieting of title back to your client of the property?
That's right. So a stay is very different. A stay would have been, for example, what the plaintiff in the creative development case was seeking. Basically an injunction that the property can't be sold. We didn't do that. The property can be sold, subject to, well, the land court statute that permits a lis pendens, subject to our existing wrongful foreclosure lawsuit, which I believe this court permits under Reyes Toledo. And if the plaintiff had a problem with this, they did have recourse. Again, it's not this court's role to maximize the returns for banks. This court is, go ahead.
Do you disagree? Mr. Rose represented that he represented procedurally, they did file an amended complaint and asserted the lost note doctrine, and then you filed an answer.
I don't recall as I stand here today. I have no reason to dispute that.
And then if those were the facts, if you did file an amended complaint, how is then your separate complaint not a compulsory counterclaim to that?
Well, I would still submit that it's based on subsequently occurring facts.
A new complaint that says we hold this note under the lost note doctrine, and you were on notice that they were moving for summary judgment based on that doctrine.
A new complaint in an existing lawsuit that came amidst litigation, motions, all of these new facts arising. Even if somehow this separate complaint did qualify as a compulsory counterclaim, again, I submit that issue is not before the court today. The circuit court would need to address that issue. The plaintiff would need to file a motion, say, hey, this separate lawsuit, it's improper, judge. This should be dismissed. This lis pendens should be expunged. Had they done that, we may have appealed. We may be here today arguing from that side of the case. But
well, one of the issues that you raised in your cert app was that you were entitled to file that as a separate complaint. You didn't have to file it as a counterclaim based on Reyes. That was one of the assertions that you made in your cert app, and that's one of the bases on which you say that you know your basically your cloud on title is still valid.
It is, and again, that's going back to this court's second Reyes Toledo decision. You know, the way I read that, it was presumed, okay, if you're going to sue for wrongful foreclosure, a wrongful foreclosure has to occur first. That case was brought to clarify that, well, no, we're going to allow it as a matter of economy. You can do it before. You can do it as a compulsory counterclaim, but you don't have to. And again, the harm really doesn't occur, you know, until after the fact in these kinds of cases. You know, the wrongfulness really does not occur. And I think it's even more important because access to appellate review is so difficult in these cases. There's got to be some source to have when a plaintiff, if this court were to adopt the rule that Mr. Rosen is proposing, anytime a circuit court made a mistake, basically a defendant, a homeowner would have no recourse, no ability to seek appellate review, to correct judicial error. I would submit to this court that it's not in a position today to legislate new rules, but that the rules that exist are sufficient. They balance the competing interests of homeowners, lenders, purchasers, everybody that's involved. Mr. Rosen suggested any time an appeal is filed, okay, well, the lender's always going to have to buy the property. That's untrue. He and I have both handled hundreds of these cases over the years. That's just not true. Sure, an appeal does raise a red flag. Again, banks, lenders are in the business of balancing risk and factoring in all these things when they lend money. It's not this court's role to maximize their return. What we have today, the way that the rule exists, number one, if you don't post a bond.
Mr. Arnsmeyer, I'll let you go a little further, but I do. Okay. You are over your allotted time.
Okay.
So.
Number one, if you don't post a bond, your appeal is moot. Unless the plaintiff is the purchaser. That does not then mean the case is stayed just because the plaintiff's the purchaser. Plaintiff can still sell the property, right? But then the inquiry becomes, are they a bona fide purchaser for value? So it's not the Citibank rule. It then becomes, is the third party a bona fide purchaser?
That's what they're arguing for, and you're arguing against.
That's right.
Correct.
That's right.
Very well.
Thank you.
Anything further at this time?
I could go on for another half hour, but my time is up. Thank you.
Very well. Thank you to both of our attorneys today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku'u ia mai ne kea aha ho'okolo ki ike hanohano o komoku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.